federal court has once again ruled that it is unreasonable for the visa officer to enforce a non-mandatory NOC requirement into a mandatory one. If you have received a procedural fairness letter after submitting a PR application saying that there is an employment requirement in the NOC code which basically says usually or is not a mandatory one for that specific code, and the officer is trying to enforce that on you, or in the procedural fairness letter they're saying that this NOC code requires a certain level of education and you do not have that, as long as that education or that licensing is not mandatory, the visa officer cannot enforce that into your permanent residency assessment. While responding to these PFLs, you have to ensure that you are citing the case laws which represent these cases to ensure that you get a fair decision and not based on visa officers' unreasonable assessment. If you have received a procedural fairness letter for a permanent residence application and now you need assistance submitting your arguments for the case, you can contact us for our expert advice.